Magandang araw, good day sa lahat. Nandirito na naman ang the Fraternal Order of Eagles, Philippine Eagles, to render public service in the field of law. A few days ago, somebody called me up consulting about legal issues, his problem, because he's being charged before the office of the prosecutor for violation of Republic Act 9262, or the Violence Against Women and their Children's Act. So I told him that the evidence presented against you is not sufficient. So do not worry. After all, it is the complainant who is bound to present evidence to prove that you committed the act complained of, and you are probably guilty. But perhaps, which is common among those who are being charged before the office of the prosecutor or even in court, he mentioned saying, paano yan? Papatunayan ko pa na ako ay walang kasalanan. That was the statement. This statement is common among Filipinos. Many among us are of the belief that if one is charged before the office of the prosecutor or in court, that he has the burden to present evidence to prove his innocence. No, that is not really the appropriate justice system way in this country. It is the prosecution, or it is the complainant, later on the prosecution, who is bound to present evidence to prove the guilt of the accused. So, before the office of the prosecutor, it is the complainant, in this case, the complainant for violation of Republic Act 9262 or Violence Against Women and their Children's Act, siya yung magpapatunay that the act complained of is true. And he has to present evidence for that purpose. It is not the respondent, meaning it is not the man who is being charged for violation of the law who should present evidence to prove his innocence. It is the complainant who should present evidence to prove the guilt of the respondent. Kaya lang, siyempre, naguguluhan na yung tao. Yan ang iniisip niya. Sabi ko, no. Do not worry, because it is the complainant who should present evidence to prove your guilt. But I repeat, this is common in this country. But what is my basis why I advised him, saying, do not worry, because the burden of proof lies with the complainant. It is the Constitution. The 1987 Constitution is clear that an accused is presumed innocent until otherwise proven guilty. Every person charged of a crime, every person charged of a wrong is presumed innocent until otherwise proven guilty. In fact, in a criminal action, the burden of proof lies with the prosecution. The prosecution has to prove the guilt of the accused by evidence beyond reasonable doubt. Medyo malalim ang quantum of evidence required to prove the guilt of the accused. Hindi yung akusadong magsasabi, wala akong kasalanan. Now, if the prosecutor, after the conduct of preliminary investigations, sabi niya, the act charge was committed and the respondent is probably guilty. Well, in this case, the prosecutor will then prepare his resolution and the information will then be filed in court. Now in this case, itong nangungonsulta sa akin, since the act complained of, allegedly, according to the woman, constitute violation of Republic Act 9262 or Violence Against Women and their Children's Act, then the information shall be filed with the family court, regional trial court. Kasi jurisdiction in this kind of case is with the family court. Nandun na sa family court. Itika muna, pag-ibig sabihin ba that if the case is already with the family court, the accused should present evidence to prove his innocence. No, 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 no. Still, it is the prosecution who will present evidence to prove the guilt of the accused. Sino itong prosecution? Of course, yung people of the Philippines, which is represented by the public prosecutor and of course the woman complainant and her witnesses and other evidence. They will present evidence in court. Now, after the prosecution presented its evidence and the accused is of the belief that the evidence presented by the prosecution is not sufficient, meron siyang remedy. Anong remedy niya? He will not present evidence. He will not present defense evidence. Anong gagawin niya? He will ask permission from the court or yung tinatawag leave of court. He will file a motion for leave of court to file a demurrer to evidence. Pag sinabing demurrer to evidence, ibig sabihin, the accused is questioning, assailing the sufficiency of the evidence for the prosecution. To the mind of the accused through counsel, the evidence for the prosecution is not enough, is insufficient to prove the guilt of the accused, and thus the criminal action shall be dismissed. Yun yung pananaw. Now, file na ng demurrer, pagtingin ng court, tama nga, the evidence for the prosecution is insufficient, then the court will dismiss the case. And that dismissal of the criminal action upon the filing of demurrer to evidence is what? An acquittal. Yung demurrer to evidence para kasing motion to dismiss. Pero ang tawag lang, demurrer to evidence founded on the fact that the evidence for the prosecution is insufficient. And once granted, na-dismiss, hindi na pwedeng buhayin because the dismissal of the criminal action in this case amounts to an acquittal. Bakit hindi na pwedeng sampahan uli ng kaso ang accused for the same act? Because by filing a second criminal action against him, that would be violative of his constitutional right against what? Double jeopardy. Kaya yung pangalawang kaso, madidismiss na naman uli, agad-agad, right? But suppose, after the prosecution presented its evidence, the prosecution presented prima facie evidence to prove the guilt of the accused. Anong gagawin ng akusado? So, na-deny yung demurrer to evidence. The accused will not present its evidence. So, titimbangin ng judge. Pag tinimbang ng judge, so anak ko, mahina yung evidence ng prosecution. The prosecution was unable to prove the guilt of the accused beyond reasonable doubt. Then the accused will be acquitted. Suppose medyo strong naman yung evidence for the prosecution, but the judge entertains doubt as to the guilt of the accused, still the accused will be acquitted based on reasonable doubt. And that dismissal or acquittal, although based on reasonable doubt, the accused cannot be charged for the second time for the same act. Why? Ganun na naman. Ano yun? If he is being charged for the second time for the same act, that would be violative of his constitutional right against double jeopardy. Di madidismiss na naman. Ganon yun. Pero kung sufficiente naman ang ebidensya, I'm sorry for the accused. Violation of Republic Act 9262, Violence Against Women and Their Children's Act, then you will be convicted. Right? Well, mga kababayan, this is another public service in the field of law by the Fraternal Order of Eagles, Philippine Eagles, through the several Limbas Eagles Club in Antipolo City, Province of Rizal. Itong Fraternal Order of Eagles, napakalaganap ito, napakarami ito sa buong bansa. Ang layunin ay makapagserbisyo, makapaglingkod. And if you want to become one of us, then you can join in any club of the Philippine Eagles in the country. Maraming salamat. Magandang araw sa inyong lahat. Salamat sa pagtangkilik sa YouTube channel Fraternal Order of Eagles, Limbas Law Corner.